Okay, there it is. Yes, sir. Okay.
Viviano Rodriguez, I'm going to mute you for the third time. Mute yourself unless I call on you.
Mute. I am unmuted.
All right, ladies and gentlemen, I have about 9 o'clock. I'm going to go ahead and call the dockets. I'll begin and ask LaSalle County and ask for announcements from the attorneys. Anyone who either does not have an attorney is not present, make sure I know you're here.
Linda, will you do me a favor? Will you call this Miss Lopez and give her the ID number and that Zoom?
Viviano Rodriguez versus Jesus Rodriguez et al.
Plaintiff Freddie, Your Honor. Hugo Diaz as counsel for Plaintiff Viviano Rodriguez.
And what do we have to hear today?
It's a motion on a default judgment, Your Honor.
All right. Give me a moment. My computer is acting normally, which is oddly. Okay, I will mark that number 1. Is there anyone here on the other side? Anyone here for Jesus or Nora Rodriguez?
Judge,
Yes.
Cristobal Rodriguez is here in the courtroom. He says he's part of the case.
All right. And I'm going to make Ms. Wiley the host in just a moment, and you can speak with her about getting a for Mr. Diaz and Cristobal Rodriguez. Thank you.
Yes, sir.
All right, Wilson County Civil Docket. In the interest of Adrian and David Alcala. Mr. Cedillos,
Yes, Your Honor.
are you on that case?
I'm here on the Castellon matter.
Okay, no, this is the Alcala children. Anyone here on the Alcala children, 15-3103 Wilson County? I'll recall. In re guardianship of Angel Jesus Castrejón Aviles.
I'm here, Your Honor. We're just, we're waiting for opposing counsel, Mr. Negron. He had an 8:30 hearing. Oh, there
I'm
he is.
here. I made it out of the hearing. Thanks, Andres.
We do have a Spanish interpreter for that case as well.
Okay, and what do we have to hear today?
Well, it's just, it's set for entry, and we have, Mr. Negron and I have a difference of opinion on part of the order that I submitted, and I sent it to Ms. Kruger this morning.
Okay, how long to hear that?
Oh, 5 minutes, Your Honor, 10 minutes.
Agreed.
Okay, I'll mark you for 5 minutes. The matter of the marriage of Jennifer and Mark Juke.
Your Honor.
Hang on a second.
Judge,
Okay, yes.
I am here for Mr. Reyes on the Alcara matter. Mr. Reyes is having heart surgery.
One more kid on here.
Okay, hold on, Ms. Juke, hold on. One more time, ma'am.
Okay, I'm here for Mr. Tony Reyes on the Alcala matter.
Never mind, I think you can hear me now. Thank you.
Mr. Reyes is having open heart surgery this morning.
Okay. All right, so just reset on request?
Pardon me?
Reset on request?
Please.
Okay, you are excused.
Thank you. Yeah.
Ask if your clients are excused.
Your clients are excused.
Thank you, Judge.
The matter of the marriage of Juke.
Yes, sir.
Okay, are you ready to proceed?
Yes, sir.
And this is, okay, I'll mark. You'll be the
He's here as
first-
well.
I'm gonna mark you A, and you'll be the first pro se case I call, the first self-represented case I call. The matter of the marriage of Joseph and Emily Plaquita.
Judge, in e-file this morning, there was a notice to drop the setting, reset on request.
Wilson County add-ons. This is a case that's actually on Judge Ellison's docket. Anyone is here for the City of Floresville case? You need to be over on Judge Ellison's docket. In the estate of Wava C. Roosh, deceased.
Yes, sir. Eloy Ita for Wanda Goforth. This is a contested probate matter, so we got removed. We were removed by Judge Jackson. And I have attorney Caldwell representing the current applicant trying to probate the will that's in dispute. And I'm just trying to get a agreed docket control order signed. And so once he gets it back to me, I was going to e-file it.
Okay, I don't see Mr. Caldwell.
No, he was unavailable. He said that he would sign the proposed order. And so I'm waiting for that.
Okay, so I'll just put reset on request and we'll wait for that order or another hearing if it's not agreed.
Yes, sir. Thank you.
The matter of the marriage of Thomas and Emily Wilson.
That case has been dropped, Judge.
All right, Mr. Akala, are you here on the Adrian and David Akala? I'm going to send you a chat. I don't know if you can hear me. Your audio is not connected. Okay, Carnes, Lissy et al. Versus Pride Oil and Gas. Motion to enforce Rule 11. I saw Mr. Weimar's here. Who else is here?
I am Judge Matt Cole for defendant Gulf Taps.
Okay.
John Quinlan is here, Your Honor, for defendant Blackbrush.
That's all the defendants, Judge. I don't see plaintiff's counsel.
All right, whose motion is it?
It's my motion, Judge, to enforce a Rule 11 agreement. Should take, with plaintiff's counsel in here, less than 5 minutes.
Okay. And have you heard from Mr. Ferraro or Mr. Graham?
I have not. I'm happy to call them if you'd like.
I'd ask you to call them. I'm not familiar with them.
You bet.
So I ask you to call them. No sense doing this over. All right. Anyone else told to be here today? Oh, here, Frio County. In the matter of the marriage of Jesus and Hernandez and Celeste Cantu.
Not present in the courtroom, Your Honor.
Interpreter also here for that case, Your Honor.
All right, I don't see anything that looks like it would be them.
Sí, existe presente Jesús Eduardo Hernández Flores.
Jesus Eduardo Flores is present, Your Honor.
Okay. Are you ready to go forward with your divorce, sir?
¿Está usted listo para proseguir con su divorcio, señor?
Sí.
Yes.
I will call your case shortly.
En En un momento le llamamos a su caso, señor.
Ok, gracias.
Okay, thank you.
Okay.
All right. Anyone else told to be here today, your case was not called? All right, Mr. Cedillos, Mr. Negron, would it do any good to confer?
No, it's just like one sentence on the order, but it's a big sentence.
All right,
Do you have it? Do you?
well, call that case,
Mr.
Mr. Negron. Okay, what's the dispute?
Well, on the order that I sent to Mr. Negron, I put on there that the clerk will issue letters of guardianship of the estate.
Hold on, Mr. Cedillos. Ms. Duke? Ms. Duke? All right, Ms. Riley, I've just put her in the waiting room. Let's leave her there until I call that case.
Yes, Judge.
I've already muted her about 4 times. I'm sorry, Mr. Cedillos, go ahead.
No problem here. No, I just on the order, the proposed order on page 2, I just I put in there a sentence that my client was going to be guardian of the estate of his son, and I did put them as co-guardians of the person. So that's where the issue is. Is that correct, Dominic?
Yes, Your Honor, you had asked the parties at the final hearing whether we all agreed that a guardianship of the estate was not necessary, and we all confirmed that a guardianship of the estate is not necessary. And so I was asking that the order, there's actually a few places where it references guardianship of the person and estate. And so conforming to your ruling, I was asking that he remove any language referencing guardianship of the estate, because the only finances the ward receives is Social Security, which is available. That's available to be managed through a rep payee. So there is no necessity for a guardianship of the estate. And I think that's why we all agreed at the hearing. And then the only other thing, and I don't know if I didn't get a proposed order back, but the only other sentence I had an objection to is on the second page, it says Ignacio Castrejón has full authority over the person of the ward. And I asked that my client's name be added on that as well, because they are co-guardians of the person. So those were the only 2 sets of changes I had, Your Honor.
Okay, Mr. Cedillos?
Yeah, well, I agree with the second part that they are co-guardians of the person of the child, Your Honor. And I don't know how the finances as far as Social Security is concerned. Ms. Ellison can chime in and say what her concerns are, but I don't know if Ms. Avilas in Illinois can be a payee, since the child doesn't live in Illinois anymore.
All right, I don't know either. I know that this was not an issue, I was told by everyone last time we were here, the guardianship of the estate. So, Ms. Ellison, is it an issue, the guardianship?
I believe it is, Your Honor, only because if anyone is able to apply for Social Security, it would have to be whoever has Angel, because the letter that came from the Social Security Administration to Ms. Avilas was stating that because he doesn't live there with her in the state, they would no longer be providing the Social Security disability to him, or the SSI to him. So whatever state he resides in, that would have to be the person that receives it, unless the court appoints a representative payee.
Okay, well, I have not appointed a guardian of the estate. So do we need to have a hearing on doing that?
I don't think so, Your Honor. I think, again, I think that this can be solved through a rep payee. It would be improper to have a guardian of the estate, because there are no funds that need to be managed by a guardian. There's a lesser restrictive alternative in place, which is a rep payee. And so I don't think there's a need, in my opinion, for a guardian of the estate. I think there's a dispute between the clients over a potential dispute. I haven't talked with my client yet to get her stance on this, but a potential dispute over which of them should be rep payee. But I don't think that should be, I think it would be overkill for the court to appoint someone as guardian of the state just to resolve the issue of who should be rep payee. If anything, I don't know if the court would be open to this. We can delineate in the order that whoever has physical possession of Angel permanently, or whoever has the right to determine the domicile, which is in this case Mr. Cedillo's client, has the right to be the rep payee.
And I would agree with that.
Be appropriate. That's what I had said, that, treat it as closely as possible as if it was joint managing conservators with one parent can establish the residence. But I would want, can you have limited rights to a bank account? By that, I mean, can you have a right to access bank records as on the account, but not necessarily the right to withdraw funds?
I'm not too sure. I
think that it should be possible to have the statement sent to more than one. I want both parents to have full access to the information about what's happening with the money. And I think it should be possible to have a duplicate statement sent out, especially if it's being sent out by email.
I think that should be possible. That should be doable, Your Honor.
I lived at my previous residence for 18 years, and the Floresville Little League for 18 years. I received duplicate copies of their bank statements, and I went and talked to them several times. I went and talked to the bank, and what the bank told me was that because I was not a signatory on the account, I had no control over who bank statements were sent to, so I couldn't stop them from sending them to me. So I just got a statement once a quarter and threw it away. So it's possible to have statements sent to more than one place. All right, so do y'all want to work on those changes and try and post that to me in chat? How do you want to do this?
I could, Your Honor. I've got the original.
All right, Mr. Negron.
That's fine. I'll just, Mr. Cedillo, if you can email me the proposed order with the changes, and then I can approve it, and then we can post it in chat.
Okay.
Okay, and what courtroom is that behind you, Mr. Negron?
This is, I'm not actually there, but this is.
Well, I know. Okay.
Yes.
It's a nice one.
Yes, yeah, for sure.
Since I was in there. Okay, so I will just put reset on request on the docket, and y'all are going to hopefully get that resolved. If not, I will be on here for quite some time, and you can come back.
Thank you, Your Honor.
Okay. All right. Thank you.
I'm going to ask you to hold on. Mr. Ramos, you were there for that case, but we need you in Frio County too.
Yes, sir.
All right, Mr. Wimar, did you find anything out in the Burns County case?
Your Honor, Mr. Cole is taking the lead on that, and I think he was going to make.
Sorry. Go ahead, sir.
Good morning, Judge. I spoke to plaintiff's counsel's secretary, and she said they'll hop on here shortly. I went back and looked at the invite, and it looked like the invite maybe had some bad email addresses. So I forwarded the link.
Okay. All right, I'll come back. Let me know when you're ready to go.
Thank you.
Mr. Diaz and the LaSalle County inmate, I'm going to put y'all in breakout room 1 if y'all will accept that, please.
That's fine.
Yes, and I changed the name of that, so.
Oh, is it LaSalle County Courthouse?
Yes.
Okay, thank you. Do you need Viviano Rodriguez in there as well or not?
Sure, yes, I'll bring it with me.
Okay, I think there's, okay. Let me get that and I'll get y'all into breakout room 1 if y'all accept that, please.
Thank you.
Lori, Mr. Cristobal Rodriguez just walked out of the courtroom. He left.
I'm sorry, Cristobal left the
Cristobal
courtroom?
left. Yes, he left the courtroom.
Okay, well,
Yes, he was here with us on behalf of the plaintiff side, but there was a misconnect. He thought he had to appear in person, but
Yeah, I told him to call one of the brothers
yes.
to see what they wanted to do.
so do you need, do you want to be in a breakout room with Viviano then?
I don't need to, Ms. Riley.
Okay.
I'll hang in here on mute if that's okay.
Okay, thank you. If anybody else needs a breakout room, please let me know who you need in the room with you. Thank you. You can post that in chat as well.
Chris Ferrara was on. I apologize for the confusion for the plaintiff.
Who is that? Who's
Judge,
iPhone?
that's our case. That's plaintiffs has shown up for the Lissy case.
All right, thank you. All right, Mr. and Ms. Duke, are you ready to proceed?
Yes, sir.
Okay. Who all is present?
Me and Mark Duke.
All right, will both of you raise your right hands? Do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Okay. All right, you can put your hands down and. All right. Ms. Duke, prior to the time this lawsuit was filed, had you been a resident of Texas for 6 months and of Wilson County for 90 days?
Yes, sir.
And you're married to Mark Duke?
Yes, sir.
And has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Yes, sir.
At this time, is there any likelihood you're going to reconcile and live together again as husband and wife?
No, sir.
Okay. All right. Since the day you married Mr. Duke, how many children have been born to you?
One.
All right. And that child's name is Keeson?
Yes, sir.
Okay. And have you gone to the Attorney General's office and had a lawsuit with them about child support?
I'm in the process of that.
All right. And where do you stand doing that?
I'm working on filling everything out.
The reason I ask that is you have your proposed final decree of divorce here, but there's nothing checked on conservatorship and support of the child.
Yes, sir. We are actually going to work together. We've been doing this for 2 years now. I'm not asking for child support. He's working on getting insurance. And we're just basically doing like joint custody, like, or where I have him so many days and he has him so many days.
Is the child on healthcare insurance right now?
He has Medicaid.
So, and you understand that actually the box that you've checked says that you are the sole managing conservator of the child and that Mark Duke is the possessory conservator of the child. And the way the Texas legislature runs things, the possessory conservator is the parent who does not possess the child. So is that what you're wanting to do?
Say that one more time, sorry.
The box you have checked on your proposed divorce decree is for sole managing conservator and possessory conservator. The box you have checked says that you will be the sole managing conservator of the child, meaning that in layman's terms, you'll have full custody, and that Mark Anthony Duke will be the possessory conservator of the child. And the way the Texas legislature drew those names up, the possessory conservator is the parent who does not possess the child. Is that what you're wanting to do?
We're not understanding it. Sorry, we've never had to deal with this.
We're just trying to do it as equal as possible.
Okay, well, that's not what you've checked. You've checked it as unequal as possible, short of terminating Mr. Duke's parental rights.
Oh, no, I do not want to do that, no.
Why don't we recess this, and you may need to talk to an attorney, but you may want to just wait until the Attorney General's office can take some action, because they can help you get all of this done so that the conservatorship and everything will be taken care of.
So we can't just do joint through the paperwork here.
You can, but that's not the way you have it filled out. And I can't be your attorney. I mean, I probably go further than I should sometimes in checking stuff off for people. But I can't be your attorney or your legal representatives, for both of you especially, and go in and just fill this whole divorce decree out for you.
Okay, well, I mean, if we're agreeing on everything, we can't do that as of today.
You can if you provide me with a divorce decree that says that. You have not. You've provided me with a divorce decree that says you have sole custody. And it also does not provide for health care insurance, and it needs to provide for health care insurance. I also
Sorry, go ahead.
talk to y'all about property. The law in Texas presumes that every single thing a married person owns is community property. The moment you get married, the law says it's community property. Now, it may not actually be. Obviously, if you bought a car the day before you got married, it's not community property, but the law presumes it is. If the divorce decree does not say either that property is community property and here's how it's being divided up, or that it's not community property because it was owned before the marriage, or it was inherited, or there's some other reason it's not community property, then the law presumes that the ex-husband and ex-wife still own that property together, that the judge forgot to divide it. In years, decades from now, your ex-spouse or your ex-spouse creditors can come back and try and get hold of part of something, claiming that the judge forgot to divide it in the divorce decree. So it's not a matter of whose name is on anything. Anything that you own that's valuable enough, there might be a lawsuit over it. Automobiles, tractors, real estate, a house, trailer, cattle, anything that's valuable enough, there might be a lawsuit. You need to spell out in the divorce decree who gets it. Okay, so I don't know if y'all can still hear me or not because you're frozen up.
Judge, you're cutting out really bad.
Well, I think it's your internet connection, not mine, but so Did you hear what I said about community property? All right. All right, I'm asking you to unmute your computer. Ms. Juke. Okay. Well, they're back now. Okay, can you hear me? Ms.
Can you hear us, Judge?
Yes. Okay, I don't know, your internet connection is not up to this hearing. So, did you hear what I said about community property? All right.
I can't hear you.
All right, I'm going to send you a chat message. I hope y'all get that. Says your internet connection is bad. All right, did you get the chat message, Ms. Juke?
I have the log off. I'm trying to.
All right, did you receive a chat message from me, Ms. Juke? Okay. It's going to put reset on request.
Are you there, Judge?
Did you get a chat message from me?
Yes, sir.
Okay. So please log off and try again. I don't know that you're going to be
I
able
just did.
All right, are folks still conferring in the Viviano Rodriguez case, or do we figure out that we don't need to confer because the other person who appeared was actually with the plaintiff?
Correct, Judge. They didn't go into a breakout room.
Okay, so let me log on to LaSalle County so I can look at that. Okay, Ms. Duke? I'm instructing you to log off and try again. And when you come back and I mute you, do not unmute yourself unless I ask you to.
Okay, I was.
I've had more problems this morning than I've had in the last 3 weeks. I don't know what it is. All right, let me log on to the LaSalle County Clerk's records, District Clerk's records, and we'll start on the Rodriguez case. All right, Mr. Diaz, who all are you trying to take a default judgment against?
Hi, good morning, Your Honor. The default judgment would be against the defendants, Jesus Rodriguez and Nora Rodriguez.
Were there a number more defendants at one time?
I'm sorry, what was that, Your Honor?
Were there more defendants than that at one time?
No, Your Honor. It's always been the two, Jesus and Nora.
All right, there's about 20 entries for citations. Did you have a hard time getting service or?
Yes, Your Honor. And we had to replace the agency that we used for process server at one point. We didn't get any of the paperwork from the first couple of service attempts that we had. Hence the multiple citation requests and entries.
Okay, I'll take judicial notice of the entire contents of the file, including the returns of service that show in accordance with the substituted service order of the court that were served by leaving a copy on the front door and by sending a copy to each of the defendants' first-class mail. All right, go ahead, sir.
Thank you, Your Honor. As the court has just stated, service was met, Your Honor. The deadline for the defendants to have filed an answer was the 6th of July, 2020, being the Monday next to the following 20 days after they were served. As of today, Your Honor, no answer was ever placed on file. It is based on my communications with my client, plaintiff Viviano Rodriguez, and his other siblings. The defendants were well aware of this lawsuit, Your Honor, so I don't know the reason for ignoring the requirement to file an answer anyway. So here we are. My client did not rush to get this default judgment, Your Honor. This is a family deal at the end of the day. But it's gone on for too long without reaching a resolution. So here we are now, Your Honor. The service returns for the defense have been on file with the court for more than 10 days, and their military service affidavits are on file. So are the certificates of last known address. Being that there is no answer on file, Your Honor, we're here
Judge, there is an answer filed.
since when?
Hey, what number is that under?
Let me see real quick, Judge. Hold on. It was filed on February the 14th of 2020.
Your Honor, I spoke with multiple, members of your court. I want to say I spoke with Arturo Carvajal and two other women, and over the last 4 months, 6 months, while we were getting ready for this default judgment, I was confirmed that no answer was ever on file, which is why we're here today on a.
I understand it, and let me ask, ma'am, so looking at the pleadings history, it jumps from November of 19 to May of 20. And you say there was actually
It was filed on February the 14th.
in there. Okay.
Yes.
All right. Well, I would ask that you go ahead and get that into the e-file system so that Mr. Diaz has a copy of it. And was it filed on behalf of both, or?
Yes, sir, on behalf of both. Yeah, I believe they're pro se.
All right, and counsel, I also let you know, I don't see a copy of the military service affidavit.
Your Honor, I attached it as my Exhibit E.
Oh, okay.
We ran
Exhibit E to what?
to my motion for default judgment.
Well, I don't see that either.
I can share my screen if it's easier.
I don't doubt it, but if there's a pro se answer on file, I'm not going to proceed. So just get them notice.
I will, Your Honor. One last thing. What date was the answer filed?
February the 14th, 2020.
Okay. How you said it was going to be available online?
I can email it to you.
I would appreciate that.
Yes, sir.
Okay.
And if you could get it into the electronic system so that I can see it whenever I log on, I would appreciate it.
Yes, sir.
Thank you, ma'am. All right, sir, if that's all you have, you are excused.
All right. Thank you, Your Honor. Appreciate it.
All right, let me get into Frio County and we'll do the Frio County divorce and then go to Carnes.
Judge, may I be excused?
Oh, yes, ma'am. That's all you have? Certainly. Thank you.
Yes, sir. Thank you.
Plan to be down there before long. They're going to let us open up courts at least part of the way.
Right. Yes, sir.
Now,
Thank
see
you.
soon.
Mr. Viviano Rodriguez is still on as well in that case, so I'm not sure if he knows he can be
Yes, sir. You may be excused, sir.
excused.
All right, calling in the matter of the marriage of Jesus Hernandez Flores and Celeste Cantu.
En el asunto del matrimonio de Jesús Eduardo Hernández Flores y Celeste Aide Cantú.
Mr. Ramos,
Yes.
Mr. Ramos, do you swear or affirm that you will, to the best of your ability, translate between the English and Spanish languages the statements of the court, the attorneys, and the witnesses?
I do, Your Honor.
All right. Are you, okay, Jesus Flores?
¿Es usted Jesús Flores?
Sí.
Yes.
Would you raise your right hand?
¿Puede levantar su mano derecha, por favor?
You solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Jura solemnemente o afirma que el asunto que está pendiente será lo que va a decir la verdad, toda la verdad y nada más que la verdad.
Sí, sí.
Yes.
Before this lawsuit was filed last year, had you lived in Texas for 6 months and Frio County for 90 days?
Antes de que esta demanda fuera interpuesta, ¿había usted vivido en ya puede bajar su mano, había vivido en el estado de Texas por 6 meses y en el condado de Frío por 90 días?
Sí.
Yes.
Are you, and you are married to Celeste Cantu?
¿Y usted está casado con Celeste Cantú?
Sí.
Yes.
Are the two of you getting along as husband and wife?
¿Y ustedes dos se están llevando bien como esposo y esposa?
Ya no la he visto, ya tengo mucho que no la miro.
I haven't seen her in a long time.
Okay. So no?
Entonces la respuesta es no.
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 Do you expect that the two of you are going to start living together as husband and wife again?
¿Espera usted que ustedes dos vayan a en un futuro vivir como esposo y esposa juntos de nuevo? ¿En un futuro? No.
When was the last time that you spoke to your wife?
¿Cuándo fue la última vez que usted habló con su esposa?
Como unos 5 o 6 años para atrás.
About 5 or 6 years ago.
And do you know where she is today?
¿Y sabe usted en dónde se encuentra ella el día de hoy?
No.
No.
Do you have any way to get in contact with her today?
¿Tiene usted forma de contactarla el día de hoy?
No, no tengo nada de forma.
No, I don't have any information.
When did the two of you marry?
¿Cuándo fue que ustedes dos se casaron?
Creo que en marzo 2013.
I believe it was March of 2013.
And since the day you married, to your knowledge, have there been any children born to your wife?
Y desde que ustedes dos se casaron, ¿sabe usted si ha habido hijos de su esposa?
No.
No.
Do either you or your wife own any large amount of property?
Ya sea usted o su esposa son propietarios de una propiedad grande.
No.
No.
Do either of you own any real estate?
¿Alguno de ustedes dos es dueño de bienes raíces?
No.
No.
Have you prepared a proposed divorce decree?
¿Ha usted preparado un decreto de divorcio?
Sí.
Yes.
Do I have a copy of that?
¿Tengo yo una copia de eso?
Sí.
Yes.
¿Dónde? Where?
¿En dónde?
¿Te la puedo mostrar?
Can I show it to you?
Yes, sir, but I need a copy for me to be able to look at.
Sí, señor, pero yo necesito una copia para mí que donde yo la pueda ver.
Okay, ese es el file, ¿verdad? No sé si la tengo en el file.
This is the one. I don't know if you have it in your file.
I do not.
No, no la tengo.
And
Aquí está.
yes. Okay.
Sí.
Please, have you given a copy of that to the district clerk's office?
¿Y ha enviado usted una copia de eso a la Secretaría del Distrito?
Sí.
Yes.
No, excuse me, Your Honor, we do not have a copy in our file.
Yes, and I didn't see one when I looked. Okay.
Aquí tengo la copia que me dieron.
And I have a copy that they gave me here.
Está el file.
There's a file here.
That may be on the original petition that he filed with
Yes,
us.
that's the petition. I think.
Esa es la petición original.
Yes, that's something else. That's where he was asking for
Eso es otra cosa.
his fees. Okay, all right. Sir, I'm going to have a copy of the divorce decree to look at before
Señor,
we can finalize this.
voy a necesitar tener una copia del decreto final de divorcio antes de que yo lo pueda finalizar para poder verlo.
Okay, ¿lo puedo llevar ahorita?
Can I take it over there right now?
Is
Yes.
that all right with the clerks? Yes.
Yes, Your Honor, he can come in and bring it to us.
Sí, lo puede llevar ahorita en este momento, señor Hernández.
Okay.
However, there are two other documents I need.
Pero, sin embargo, hay otros dos documentos que yo necesito.
You have to file a certificate of last known address.
Necesito un certificado de último domicilio conocido.
De ella.
Hers.
Hers.
De ella.
Okay.
And you have to file a military service affidavit.
Y necesita también un documento judicial de servicio militar
that shows that your wife is not in the military service.
que diga que su esposa no está en el servicio militar.
Okay.
¿Ok?
Okay.
Have you already filled out those last two documents?
¿Ya usted llenó esos dos documentos, esos últimos dos documentos?
Sí.
Yes.
All right. So please take them all to the district clerk's office and they will scan them and email me a copy.
Por favor, entonces llévelos esos documentos ahí a la oficina del distrito, a la secretaria del distrito, y ellos me los van a enviar a mí.
Okay. ¿Tengo que sacar otro día de corte o no?
Do I have to get another court date?
Not if you get this done while I'm still online.
No, mientras yo esté ahorita en línea, lo puede hacer.
Okay.
So before we go any further, then let me tell you that the law in Texas presumes that everything a married person owns is community property.
Y la ley en Texas asume que todo lo que una gente posee es propiedad comunitaria, bienes mancomunados.
Okay.
If the divorce decree I signed does not divide up property, then the law presumes that you and your ex-wife still own it together.
Y si el decreto de divorcio que yo firme no divide todo, entonces la ley va a asumir que es propiedad de ambos.
Okay.
So
Okay.
it's very important that anything valuable enough for a lawsuit that you spell out in the divorce decree who gets it.
Entonces es muy importante que cualquier cosa para una demanda, algo valioso, que usted lo ponga ahí, que esté dividido en el documento.
Okay, está bien.
Okay, all right.
And sir, are you simply proposing that you keep what you have in your possession and your wife keep what she has in her possession?
Y usted lo que propone es que lo que usted posee, usted lo desea mantener en su posesión, y que lo que su esposa posee, o sea, ella en su posición, que ella lo siga poseyendo, lo que ella tiene.
Sí, está bien.
Yes, that's fine.
Okay, then I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. The respondent could not be located, or she was served by posting. I'll find that the plaintiff had made reasonable attempts to locate her before she was served by posting, that her answer date for service by posting has come and gone. There's been no response. The petitioner had been I'm sorry. Go ahead, Mr. Ramos.
Y que encuentro que tengo jurisdicción en este asunto. Se han sido 60 días que ha estado archivado. El demandante ya hizo varios intentos de hacer la publicación. Ya hubo una fecha para respuesta. No hubo respuesta por parte de la demandada.
Sí.
Okay. And the petitioner had been a resident of Texas for 6 months and Frio County for 90 days.
Y el peticionario ha sido residente de Texas por 6 meses y el condado de Frío por 90 días.
The marriage between the parties has become undermined due to discord and there's no likelihood of reconciliation.
Y que el matrimonio de las partes ha sido socavado y hay discordia y no hay forma de reconciliación.
There's no children born during the marriage and none are expected.
Y no hubo hijos durante el matrimonio y no se esperan hijos.
And the proposed division of the marital property is just, fair, and equal.
Y la división propuesta es igualitaria y justa.
I am not going to pronounce the divorce right now, but when I have received all of the 3 things I need, the decree, affidavit of address, and military service affidavit, I will do so.
Y no voy a pronunciar ahorita el decreto de divorcio hasta que tenga esas 3 cosas que necesito: el decreto de divorcio, el último domicilio conocido y el affidavit del servicio militar.
Okay.
Okay.
All right. Good luck, sir.
Buena suerte, señor.
Okay, gracias.
Okay, thank you.
All right. And Mr. Negron, Mr. Cedillos, do we still need Mr. Ramos? In your case, sounds like probably yes. Well, I guess they're busy.
Your Honor, we might have, I think, an agreement and order in place. Mr. Cedillos is working on that. We've all been talking about it. And so
But
we're just
perhaps
waiting to
not.
get it from him.
But perhaps not.
Correct. That's true, Your
Okay.
Honor.
So, Mr. Ramos, I'll ask you just to hang out for a while if you're available. And
Certainly.
we have to go into another hearing. I'm going to ask Ms. Riley to turn on the interpretation feature. We went
Yes,
back and we have it available every time.
I'll be here.
Turned on.
Thank you, Judge.
Okay, do we have an announcement in the Karnes County case? Lissy versus Pride Oil et al.
Yes, Judge, I think it'll take about 10 minutes, maybe less.
All right, are there any documents I need to look at?
There's a motion, there's a Rule 11, but I think I can explain it to you without even you looking at it. But everything's on file, though.
All right, well, let me exit from Frio County and sign into Karnes. All right, when was the motion that we're supposed to hear today filed?
Hang on one sec. Filed on February 16th. The motion to enforce Rule 11 agreement, Judge.
Okay, I have the motion in the exhibit. Go ahead, sir.
So Judge, the short version on this is plaintiffs have complied with the first requirement of the Rule 11 agreement in that on March 3rd, they added all the required parties and they requested citation be mailed to the plaintiff's offices, plaintiff's counsel's office. But we're also obligated to add these parties to the lawsuit or to have the parties served, excuse me, by October 2nd. We've been kind of going around for the last couple months to get them actually served. And I just would like to put this in the rear view. And I think the most efficient way to do that is to have an order from the court. They're obligated to serve these parties by October 2nd. That hasn't happened. And so I think an order from the court today requiring that they be served within 7 days would enable us to get past this and move on. So that's what we're asking for.
Your Honor, if I may reply.
Yes. Are you Chris or Peter?
I'm Chris Ferraro, Your Honor.
Okay, thank you.
Peter Ferraro was my father, and he was the attorney on this case, and he passed away.
I'm sorry, I did not know that. I just.
Yeah, unfortunately, November 16th. November 12th. I entered an appearance in this case on November 16th. It's my understanding that the purpose of the Rule 11 agreement was to add the parties if they were unable to resolve the dispute between the parties that were in the case of mediation. Mediation was held on January 27th. It did not resolve after that. We agreed to add the parties. It's an oil and gas case. Obviously, there's a lot of parties to add that are necessary parties that are mineral owners. There were 43 of them. There's a lot of research that has to be done to make sure the well was from 1961. So there's a lot of research that had to be done to make sure that all the conveyances were accurate and the right parties were all added. That was all done. The amended complaint was filed. We requested citation from Karnes County to serve everybody on the 3rd. We have not gotten those citations from Karnes County. As soon as we get them, we intend to serve everybody. All of that is in my February 22nd response to their motion. And in that response, we also set forth that we would provide the amended and file the amended complaint, adding all 43 of the necessary parties by March 3rd. And we obviously did that.
Judge, I don't want to quibble about things that aren't that important, but the short version is this is an August Rule 11 agreement that required these parties to be added by October, be served by October. There was no mention of mediation at that time. We talked about doing mediation. We ultimately did do mediation, but the short version is I've never before in my entire career filed a motion to enforce a Rule 11, never had to. This is the first time I've had to do that. I'm pleased that 2 weeks after I filed the motion, plaintiffs added the new parties, but we are sitting 5 months after they were supposed to have served the new parties. And so at this point, like I said, I think probably the most efficient thing to do is to have the authority of the court help us get these parties served by a date certain. A reasonable date certain.
In Your Honor, as soon as we get citations, we will serve them.
Is the district clerk's office on? When can they expect those citations? You're muted, ma'am.
Yes, Judge. We did receive the request on March 4th, and we prepared all 43 on March 5th, and were mailed out March 5th to the Attorney Graham Law Firm.
Okay.
Okay. I will check and see if we've got them, Your Honor.
All right. So, Mr. Cole, what would you propose would be a reasonable time to get those served?
I think 7 days. Certified mail, you can get them out today.
And for the ones that come back?
I mean, I'm not gonna, for ones that, if he's got evidence that they tried to serve and they didn't, and somebody's address is wrong or somebody's not successful, I'm not gonna hold his feet to the fire on that. I don't care about the 42, by the way. That was their choice. I've got 10 people that I care about. And that's my proposed order, which I'm happy to either e-file or email to the court, whatever you prefer, really only addresses 10 of those individuals. I don't care if he never serves the other 30 something.
Your Honor, to be able to resolve the claim, everybody that's a mental illness needs to be involved. So.
And that's fine. That's his position. That's not my hearing today. My hearing's on 10.
All right, do you have your proposed order, Mr. Cole? If you could just post that in chat to me.
Sure. Oh, it says it's blocked. Can you only take PDFs?
Yes, I believe so.
Okay, I'll just convert it real quick. Give me 1 second. I apologize, Judge.
Thank you.
Your Honor, while Mr. Cole does that, may I have 60 seconds on just a housekeeping?
Yes, sir.
I'm not trying to be difficult. There's been so many new parties and new papers gone different direction, but as of the March 3rd, 2021 plaintiff's fourth amended petition, Mr. Chris Ferraro is actually not counsel of any record. And the only person I see reflected on there is someone by the name of Bob Graham or Robert Graham. And so I guess it would be helpful for us to know if Mr. Chris Ferraro is making entry of appearance and is to be noticed, or what his status is in the case.
Your Honor, on November 16th, I filed a notice of appearance in the case.
And I guess my problem is just on their live pleading, he's nowhere in it, and hasn't been copied on any of the papers or otherwise since then. So I know we had a problem with getting folks onto today's hearing, and so with Mr. Chris Ferraro's statement on the record that he's before the court, I guess that's good enough for me, and we'll notice him. But again, perhaps some of the court's problem may have been that on the live papers, he's nowhere on them.
In the future, I'll add my signature block to all filings.
Okay, and I would urge you, Mr. Ferraro, to also just post something or file something for one of the judges to sign stating that you're the attorney of record. Many years ago, I worked for a law firm where the partner I worked for did legal malpractice, and there was an attorney who passed away in Houston. And the attorney who took over the case made an appearance, and he was noted down by the judge on the docket sheet as the new attorney. And the district clerk sent out the DWAP notice to the deceased attorney, and nobody showed up. And that went all the way to the Texas Supreme Court, and the Texas Supreme Court said the rules then, they may have been changed, but said that the attorney of record is the attorney of record until there's an order signed by the judge substituting someone else, and that the clerk had no duty to send the real attorney who was alive the notice, and the DWAP was good.
Okay. Thank you.
Okay, all right. I will, okay, I'll order that within 7 days of receipt of the citations from the district clerk's office, that the that the plaintiffs initiate service, send them out by certified mail, put them in the hands of their service company if they're going to have them served in person. So I will edit this a little bit and I'll post it back to everyone.
Thank you, Judge.
Thank you, Your Honor.
Give me just a moment and I'll. Okay, I've just posted that in chat to everyone, so you'll have a non-file stamp copy. All right, if that's all you have, you're released. I'll let you know that I'm going to be sitting down with the judges in all 5 counties this week and get our rules revised so that we can get jury trials back on track. We will have that happening before long. I expect that in most of the counties, at least, we'll be appearing just in masks and not the social distancing. So it'll be a lot more viable to try and actually try something.
Your Honor, is the anticipation that the hearings would go back to in-person attendance as well, or?
I'm happy to do most things by Zoom. So no, I'm not necessarily making it mandatory. I would think that we would probably, I don't know how that's going to work. We'll have to see. I don't know how big of a pain it would be to try and have Zoom and live. We might bifurcate the day and have part of the day live, part of the day by Zoom, something like that. Okay, all right, so y'all are excused. Release.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.
All right. All right, Mr. and Ms. Duke, you're back.
Yes, sir.
Did you hear what I had to say? Okay, you've got.
No, I don't have
electronic
the
device. Okay, I just muted you. You have 2 electronic devices going, apparently. Is that correct? You're still muted.
No, should be just be one.
Did you have 2 electronic devices going?
No, sir.
All right, well, I don't know what the cause of it is. The only way I've ever seen this happen is when people have 2 electronic devices. Because what happens is that my computer is playing the sound of everybody else, but it understands that it can't take and feed that sound back into the microphone going back out because it causes problems. That, for some reason, is happening on your device. So I'll just tell you that the law in Texas presumes that everything a married person owns is community property. It's not a matter of whose name is on it. It's not a matter of whether you're fighting over something. If you own something today, the law presumes it's community property. If the divorce decree doesn't say that it's being divided and given to one of you, or as divided up community property, or say that it's not going to be divided because it really is separate property because, for instance, you owned it before the marriage. If those things don't happen, then the law presumes that I, the judge, forgot to divide part of your community property and that you still own it even though you're divorced. So whenever you prepare a divorce decree that reflects what your agreement is on the conservatorship and support of your child, you also need to make sure that that divorce decree divides up any property either of you own or that both of you own together. Anything that's valuable enough for there to be a lawsuit over, you make sure that it says in the divorce decree who gets it. All right, so are you clear on that?
Yes, sir.
All right, then we'll let you reset this whenever you have your new divorce decree. Okay? So get with the clerk's, get with the coordinator's office to get a new date. You have the new divorce decree with all of the stuff corrected and put in there. All right. All right, District Court in Frio County. Is that gentleman, Mr.
Your Honor, he dropped
Hernandez?
off already. I just sent it to you by chat.
Oh, by chat, okay. Right, hold on. One new message. Here we are.
Your Honor, he's back upstairs. We're going to set up a computer for him to use because he can't seem to log back on his phone. So if you give us a few minutes.
Okay, thank you. I'll see if I have any questions. If I don't, well, we won't need them.
Okay.
I'm going to need to speak to him.
Okay, Your Honor. The only thing is my computer does not have a camera, but he is standing here.
That's fine. All right, Mr. Ramos.
Yes, sir.
All right. There's no camera, but we're back on with Mr. Jesus Hernandez. All right, Mr. Hernandez, I've looked at all of the documents you filed.
Señor Hernández, ¿ya vi todos los documentos que usted archivó?
Sí.
Yes.
The only problem is with the military status affidavit.
Y el único problema es con el documento judicial de servicio militar o de estado militar.
Okay. You check that you do not know if your wife is in the military.
Y usted marcó ahí, checó el cuadrito de que no sabe si su esposa está en el servicio militar.
And that's good. I want you to be honest.
Y eso está bien, quiero que usted sea honesto.
But I have to know that she is not in the military.
Pero necesito saber que ella no está en el servicio militar.
Okay.
There are two different ways you can show that.
Y hay dos formas diferentes en que usted puede demostrar eso.
If you look at the affidavit that you signed,
Si usted ve ahí el documento oficial, el affidavit que firmó,
there is a web page that you can go to and type in your wife's name and date of birth and social security number and see if she's in the military.
hay una página de internet ahí en esa hoja que usted firmó y usted pone ahí el nombre de su esposa, la fecha de nacimiento de su esposa y el seguro social y ahí le dice si ella está activa o no.
Or
No me sé el número seguro social de ella.
I don't know her social security number.
Or you can check the middle box and show some other way that you know your wife is not in the military.
O puede checar en el cuadro de en medio y decir que hay otra forma, saber que su esposa está en el servicio militar.
For instance, if your wife has some health or physical problem that would keep her from serving in the military, or if she is too old.
Por ejemplo, si usted sabe si su esposa tiene problemas de salud o físicos para estar en el servicio militar o ya está la persona muy vieja.
So I will keep this copy of the divorce decree and the certificate of last known address.
Entonces voy a mantener esta copia certificada del último dirección de domicilio conocido y del decreto de divorcio.
And wait for you to file a new affidavit of military service.
Y voy a esperar a que usted vuelva a archivar un affidavit de servicio militar.
Okay.
Ok.
¿Me va a dar otro?
¿Perdón?
¿Otro día corto me va a dar?
Are you going to give me another court date?
No, sir. You do not need another court date as long as you get that affidavit signed correctly. If I have a problem with it, I will tell them to get you a court date. But as long as you do it correctly, I will just go ahead and sign the divorce decree whenever you file that.
No, señor, no necesita hacerlo eso. Mientras usted firme ese certificado correctamente, está bien. Y si no, de esa forma yo lo voy a leer y de lo contrario sí le voy a dar otra fecha de corte para que se presente.
Okay.
Y de esa forma le voy a dar el decreto de divorcio.
Okay.
Ok.
All right, I wish you good luck, sir.
Le deseo buena suerte, señor.
Gracias.
All right, have a good day.
Que tenga buen día. Thank you.
Okay. Yes,
Judge, I spoke to Mr. Cedeos, and they said that they do not need the interpreter.
Ramos? Okay.
Right, and they're not going to need you for today. They're
All
working.
right,
on
well,
it.
that sounds like we're finished then.
Yes, sir.
May I be excused then, Judge?
Yes, ma'am. Everyone is excused. I'll ask Ms. Riley to end the meeting. I'm going to exit it. You all have a good day.
Thank you, Judge.
Made from Texas law helped out. And where it says search document, you can put military status affidavit.